Good afternoon and welcome to this UKAA webinar. As you can see, we've got a very distinguished panel of lawyers waiting to talk to us about probably something that's even more topical following Prime Minister's announcements yesterday. Today we're covering the implications of COVID-19 for build-to-rent development and investment. I'm going to hand you over to my co-presenter, Rebecca Lewis from Morgan Sindall Investments. I'll perhaps do a general introduction to each section, but Rebecca, who's the smart one of us, will ask the difficult questions as it goes through. So over to you, Rebecca.
Thank you, David. Welcome, everybody. So today, it's a sort of quick canter through the legal implications of COVID-19, as David said. So we're hoping to get an insight into the sort of trends and themes that are coming up as part of all the legal aspects of what's going on out there right now, both now, currently, and then looking to the future and what we're likely to see going forward. So we're intending for this to be around 60 minutes. We're going to cover off planning, construction, development and funding. We've got a very distinguished panel, as David has said. So we've got Andrew Yates from Brian Cave Leighton Payson, David Cordery from Trowers Hamlin, Duncan Salmon from Charles Russell Speechley, Ian Atkinson from Wimbledon Dickinson, Nicholle Kingsley from Pinsent Mason, and Anastasia, I'm really sorry Anastasia, I'm going to pronounce your surname terribly, so we've got Anastasia from Osborne Clark as well. And they're intending to sort of take us through these key topics and then talk about them in more detail. So firstly, I'm going to hand over to Nicholle, who's going to kick us off in regards to planning.
Yes, thank you very much, Rebecca. So the first question really was about how issues are currently being seen in the planning context. And I have to say, been really impressed actually with how all sides have had the willingness and the enthusiasm to progress with the planning process. Clearly, we'd seen a number of difficulties, but the government was quite quick to react initially in relation to, for example, extending permitted development rights. So you saw that you could have health authority change of use or temporary construction buildings for use within the health sector and for local authorities to do the same. Then we saw that there was actually a change in relation to virtual meetings, and that is where a number of the issues originally cropped up. And that relates back to a 1972 Act, actually, where people had to attend in person the council committee meetings and other meetings, actually. So the Coronavirus Emergency Act helped to change that. And then we saw secondary regulations coming through, which enabled local authorities to meet virtually. So in terms of how each local authority has adapted to these changes, it's fair to say there's been a number of differences. Some have embraced it a lot more enthusiastically than others. But I think that probably reflects the level of resource some local authorities have as against others, in relation to how they can apply that to the planning process, as distinct from, for example, having to redirect some of their resource or deploy it into other areas to cope with the emergency situation. So yeah, there's been a very sort of mixed and varied reaction. We've had a number of virtual meetings now on planning committees. So there have been a number of decisions that have come through the planning process. And we've also seen that government are now looking to the next steps in relation to other areas of difficulty in the planning process. And I know, Rebecca, I think one of those that you mentioned to me previously, and one that the industry have been talking about, is in relation to the expiry of planning permissions. So developers clearly concerned and landowners about keeping hold of their planning permissions because they can't actually get in process the mechanisms they need to clear the pre-commencement conditions and go on site within the time limits that they have. So that is one area the government is looking at. They could have changed it like Scotland did with a change to the primary legislation, but they chose not to for various reasons. But it is something definitely still on their radar in relation to timescales, and so that is timescales to implement your planning permission. I think there are other challenges, and cash I've mentioned already. So for example, SIL payments, they're triggered pretty much up front. There are instalment mechanisms that you can agree with the local authority, and SIL phasing, provided you set up your planning permission to be able to do that. But again, the government is still really working through those to help developers and landowners carry on with the planning process and try and use planning and development as a means to help the recovery of the economy. I was also asked what the implications for challenges and appeals, and of course the Planning Inspectorate have been one of the more slower entities to catch up with the virtual meetings. They are starting now in May, and the government again was focused on helping the Planning Inspectorate to embrace and hold virtual meetings. So we'll see how those pan out. As a result of that, there are delays to the appeal system, but I think that we will see those as they get going, a bit like court has been hearing virtual hearings. As Planning Inspectorate comes on board, I think they'll iron out their issues, and we'll start to see some of the inquiry processes recommence. I know that the Planning Inspectorate does feel now that we'll see a change coming up, looking to the future, in relation to how inquiries and hearings will be held, and they think that we won't keep hold of the system that we've got at the moment in relation to the three distinct ways that you can carry out an appeal, which is your written representations, your hearing, and your public inquiries. They don't think that they will require everybody to be in the same room at the same time. So Rebecca, I hope that gives you a feel and a flavour for an overview on the planning side, as to what's generally happening in the market and with the industry.
That's really helpful, thank you. I think just picking up on some of the points you've raised, Nicholle, it'd be great to understand when do you think these timescales for the changes are actually, when are we going to see any of the changes come in?
It's difficult to say. I mean, Simon Gallagher, Director of Planning in the government, said that he was looking at it and it is one of their next priorities. But as I said earlier, they could have actually changed it at the beginning in the same way that Scotland did, because they had the Coronavirus Emergency Act, and they didn't do that. Now, they say it's partly because they thought people would take advantage, and they didn't want to see sort of it's the sort of use it or lose it position previously. But we are now definitely seeing, in relation to discussions with local authorities, workarounds. So that is the one positive, is in that local authorities are generally being quite pragmatic. So there are a number of ways in which you can effectively get past this issue, provided, of course, you've got the local authority on side.
That's really helpful. So kind of advice to anyone out there facing any of these, especially the expiry of their planning permission or sale, is to sort of speak to your local authority and sort of see if you can try and get a collaborative conversation going.
Yes, absolutely. Alice Lester, who's the head of Brent, was on a panel discussion.
Thank you so much.
Recently, and she was saying their local authority, for example, are discussing with developers and landowners and using a number of mechanisms to help achieve the same outcome while we wait for any changes from government. So yes, absolutely. Transparency and openness and speaking to the local authority is definitely a high recommendation.
Nicholle, thank you. That's great. We've got a question on from Peter Sloan of Love to Rent about a question of a more dedicated planning class of BTR sector. I think I'll save that to the end, and we'll maybe come back if we've got time. Right now, I'd like to just move on to the interesting issue of construction. What are the legal issues we're seeing now and potentially in the future on the construction side? And Duncan, can we kick off with you and your views on this potentially controversial topic?
Of course, David, thank you. Afternoon, everybody. Something of a roller coaster ride for construction over the last 6 or so weeks. We'll all remember that we started off with a rather confused message from the government. Was construction to be shut down or was it not? Not according to Generic the day after the initial shutdown. With then all those of us who are in focusing on some of the detail we'll get to in a moment about, are contractors entitled to an extension of time? Are they entitled to compensation in relation to the effects of coronavirus?
We seem to have lost
and in particular, the site operation 1, as we call it, SOP2, which lasted about half a day, and SOP3, which we're now working to, which sets out a hierarchy of steps to be taken to attempt to make sure that construction activities can be undertaken safely. Interesting this morning, after the Prime Minister's announcements of last night, a great deal of media coverage of various sites in London with workers queuing up to get in. Some criticism from Unite in relation to can their members actually work safely. So that there are going to be some real challenges. We're going to need to look at how does the industry as a whole, build to rent in particular, but all the principles are the same, work in what I think will have to be a collaborative way if we're going to get through this, because the contractual position itself, which Ian and I will discuss in a bit more detail, isn't always that favourable as far as contractors are concerned in the present circumstances under the standard forms anyway. So we will need to look at what has to be done to get these projects completed.
And if I can just pick up on that point there on the collaboration as well, Duncan, I think what was evident to me and very pleasing to see was when we did go into lockdown, and it became evident that the impact on the construction sector was going to be quite significant. A lot of people came to me in the first instance, employers and contractors, and said, look, we just want to do what's right. We want to work together. We want to do what's best for the project. So we were advising, not just within the framework of the contract, which, as you've said, isn't necessarily clear, but also what's best for the project. And some parties were quite quick to come to an agreement and say, look, the contract's not clear on these points. It's not clear on COVID. So let's have a side agreement or a variation to the original agreement to determine how we will deal with it. And I think that was really pleasing to see that, more often than not, people talk warm words of partnering, but it was actually quite evident at the outset.
Yeah, no, absolutely. And for those of you who haven't read it, there's an entire paper that's been issued by the Construction Leadership Council on how to deal with the sorts of issues that Ian has just outlined, how to amend contracts, what the issues are, and if you can't get that far, how to actually then try and deal with the disputes through mediation, escalation to senior management and so on, all of which is to avoid ending up in litigation or adjudication. What comes first? Well, the project comes first after health and safety of the workers, of course.
Okay.
I think looking at some of the principles maybe, but before there are some questions you want to ask, I think, Rebecca. I think we're generally in agreement, aren't we, Ian, that as far as time is concerned, COVID-19 falls within the definition of force majeure. There's been a great deal of learned legal argument about it, but generally that has been the accepted position, I think.
Yes, although as is, to give a proper lawyer's answer, it depends on the contract. So yes, if we're looking at a standard unamended JCT which does address force majeure, albeit in a very vague fashion, then yes, I think it would probably be determined for, or corona, the impact of corona on the project would probably be classed as a force majeure event. And there's some, I think the most recent case law that's relevant to pandemics or epidemics is from about 1920, but suggests that force majeure does apply. I'm not aware of anyone actually testing the definition of force majeure under a JCT, but leaving that to one side, I suppose the only thing to say is that more often than not, in the larger projects, of course, the lawyers come up with their schedule of amendments to the JCT, and more often than not, we like to tinker with the definition of force majeure. So before we can categorically say coronavirus would be a force majeure event, you'd be well advised to look at your actual building contract and to see how force majeure is defined, because some of them are defined incredibly narrowly and some of them are left really quite wide open, and any unforeseeable event, etc. But force majeure would generally entitle the contractor to an extension of time. But of course, when it comes to his additional loss and expense, usually that's not captured by the definition of force majeure, or certainly not usually under a JCT contract. So the contractors will, in all likelihood, be looking for some other ground in which they can capture not only an extension of time, but loss and expense. And I think for that, you have to look quite carefully at how the developer or the employer has behaved at the outset of the lockdown. So if the developer or the employer has determined that the site should close and they've made that decision, or they've put in place different working arrangements, then they've left themselves open to a potential employer variation or change, which would unfortunately lead to a claim for additional loss and expense. And that's where there are other grounds as well under the JCT where it just, to me, becomes a bit murky, Duncan. And we've talked previously about change in law and whether or not the government stance actually could be determined as the exercise of a statutory power. Of course, it's not clear, is it? It's not clear on the face of it.
No.
So, what do you think about that? Is there anything you want to add on that point?
Well, what was interesting is that the note coming post shutdown always talked about force majeure, and they talked about a change in legislation because, most of the ones I saw anyway said that. And the response, of course, when we're acting for employers was, no, that's absolutely wrong for the reasons that you've just said. That having been said, that if you look at what is now being determined by government, I think you could run an argument, certainly, that there has been a change in legislation which would have an effect, certainly would have an effect on transport, on the supply chain, and then develop an argument along those lines that actually this is a change in legislation which has caused loss and expense as far as the works are concerned. And I think it's going to be interesting going forward to see where the legislation goes next in relation to the supply chain. Picking up, just going back though, wheeling back and picking up on your point about instructions, that I think is going to be the key thing going forward, because inevitably working is going to be inefficient. If you look at SOP3, there's another really interesting section in the FIS, which is the fit out organization, about how you can go about fitting the internals into buildings in incredible detail. But what it all demonstrates is that it's going to be inefficient. And if it's going to be inefficient, then as I think you said when we were discussing this before, instructions come from the employer, and an employer shouldn't actually be giving instructions that are going to lead to time and money unless he absolutely has to. But if a pragmatic decision needs to be made to get a project delivered, and rather than saying we can't get these types of kitchens at the moment, and the employer saying, well, it's a D&B contract, you go and sort it out, well, he may actually need some help to sort it out. He may need an instruction, because if he doesn't get that instruction, then we're not going anywhere. And there, I think, that's going to lead to the kind of collaborative approach being essential, that we may need to reset. We are going to need to reset, and we may need to renegotiate the terms of contracts to deal with that. Because if there's a standoff, then that means no one goes anywhere.
Yeah, I think that's a really important point you make on the materials. Obviously, the usual position is that the contractor would take responsibility for both sourcing and therefore the availability of materials and also the price of them. So if there's a price fluctuation, then unless it's a provisional sum item, then that's a contractor risk. Now, it's quite easy to see that there are going to be supply chain problems, as you've said, whether that's in our domestic supply chain or whether that's coming from abroad. There is not going to be the choice of materials that people envisaged when they entered into the contracts. So the employer or the developer or indeed the investor has a decision to make. Are they going to play hardball? And are they going to say to the contractor, no, that is the material that I want, that is the finish that I want, and you must go and get it, and you must, get it at whatever cost. But in doing so, they will prejudice the completion date of their project because it'll take longer to get. Or do they make a concession and say, actually, okay, we'll not take what we originally wanted as our first choice, and we accept you can't get the second choice either, but actually the third choice will be okay, and we'll take the third choice, but if that means that you can complete the project on time. So again, yeah, there's a theme there on collaboration and whether or not you use the contract as a hammer, excuse the pun, to sort of batter the contractor into submission, or whether you use it as a framework to try and come up with a solution that perhaps suits all.
Yeah, which has got to be the pragmatic way forward, I think, because otherwise we'll just get mired in disputes, and that isn't going to help anybody. This is, to use that rather hackneyed phrase, we're in entirely new territory here. It is unprecedented and so on and so forth. And the contracts don't necessarily deal with it as we would want. The employer can take the hard position, as you say. Where's that going to leave? Where is that going to lead to? But one of the things that does intrigue me is what, and we'll be coming to this later in this webinar with our colleagues, is what the view of funders is going to be in relation to this. Because it's one thing the employer and the contractor making a pragmatic decision. It's something completely different to the funder saying, well, hang on a minute, I've funded this on a particular basis. We need to look again at various aspects of this funding agreement if that's what you're going to do. But going forward, certainly that's the way I see it. And also then looking at how are we going to adjust these contracts to actually fit the unprecedented times in which we now find ourselves. What are we going to say about extensions of time? Well, what are we going to say about particular loss and expense type provisions? It's one thing resetting the contract, which we could do on a once and maybe sequential basis, but we are going to need to look at new contractual terms. We're going to need to be able to say to contractors, if we're acting for the employer, look, you can have an extension of time, but it's got to be directly related. You're not going to use this as a catch-all for every single delay and inefficiency on your part, which is going to be a challenge, I think, for the drafting and for the factual situation that arises out of that.
And I don't know about you, but I've seen a lot of proposals for coming from contractors, usually to try and address COVID, and it's been incredibly diverse. So, I've seen some people take exactly the approach that you've outlined, and they've come up with a very narrow definition of COVID, and they've said it's any direct consequence of the COVID event. I've seen others come up with much wider drafting, which is more to do with restriction of labour and materials, which to my mind looked awfully similar to some of the Brexit drafting I was seeing last year. Yeah. So what's clear is that there is no standard drafting yet. There's been nothing released by the JCT for people to sort of hang their hat on, and so I can't help but think that for the next three months or so, we're all going to be arguing and negotiating different COVID drafting on a project by project basis, which probably isn't very helpful. And you're absolutely right. The funders already on some of the projects I've been working on have been scrutinizing the COVID proposals that we've been trying to lever into contracts, and that's only going to get worse too as well, because these aren't just, it's not just an agreement between two parties you're sorting out here. You're sorting out between employer, contractor, subcontractors, funders. It's an awfully long chain of parties in that negotiation. So that's going to be an interesting one to resolve. And I also think I think as lawyers, we're all going to look very closely at force majeure drafting from here on in, aren't we? I think that the days of force majeure being left untouched in the JCT are probably over. It's almost going to be the norm that we're going to try and tinker with it. But no doubt the contractors will fight against that, because the way it's drafted at the moment is seemingly in their favour. That is until we hear a decision from the courts that perhaps might suggest otherwise.
Yeah, absolutely. I agree with that. And the other clause, which I don't think any of us really paid much attention to over the years, was clause 811 of JCT, which actually allows termination after 2 months suspension, which for many contracts, if they're not all going back this week, as suggested by the Prime Minister, will actually come around in the week after next, which could actually lead to contracts terminating. And I don't think anybody really looked at that in the past. I can't think of a single occasion where a contract's been determined because of a suspension due to force majeure.
No, and of course you can't foresee, you can't work or predict who that's going to benefit, because it's going to depend entirely on the contractor's financial affairs and the project in question. If we're just talking about going back and completing some snagging items and perhaps he's not interested, then yes, he might take advantage of that termination provision. But similarly, if it's the outset of a project and the employer's got cold feet, then it might work the other way. So yeah, who knows? Yeah,
no, absolutely. But it's going to be changed. That's for sure. I think it's not going to be left alone. So in terms of other construction issues that we've been looking at, we're going to need to look forward. We're going to need to look at what funders are doing. I've had one particular project which was about to start where a bond suddenly wasn't available. I don't know whether you've come across that at all, whether that's an issue in the market as far as you're concerned.
It's certainly going to be, I think. I mean, you couldn't help but notice post-Grenfell, the insurance market really hardening up. And I think the bond market's been following suit anyway. Well, I haven't had any projects that have actually had the need to call for a bond since, take out a bond, not call upon the bond, but take out a bond in the period since we've been in lockdown. But it's quite easy to imagine that the cost is going to go up, because sureties will be looking at the risk. They'll be seeing potentially new disputes that perhaps hadn't been envisaged. They'll be looking at the liquidity or the financial covenant strength of the contractors. That's all going to drive the price upwards. Those costs inevitably are going to get passed on somehow through to the developer. And you have to then question whether or not the bond still offers value for money. I mean, what do we think? Do we think that the solution lies in taking out a bond for a lower amount? Maybe dropping to 5% instead of 10%?
It's a difficult call. I mean, I've been asked the question that how are we going to, by an employer, how are we going to secure ourselves as in relation to this insolvency risk, which is very, very difficult indeed, because all of the traditional things that employers do, like bonds, which are going to be, as you say, possibly too expensive. Do we then say, right, we're going to have a larger retention, we're going to change cash flow in some way, but all of which then just exacerbates the situation? I mean, it's rather a difficult one to fix, I think.
So it could be, and we're reaching out here, but it perhaps it's the time of the project bank account. Perhaps that might offer some solutions in that the cash remains available, or retention bonds. Maybe we're going to see a flurry of people taking out retention bonds, which provide comfort to both parties, albeit again at a cost, though. I'm not sure.
No, it is difficult. I mean, talking to my employer clients or the developer clients, people in the build to rent sector, they tend to have supply chains that they have good long relationships with. And I think that those relationships may actually work on a collaborative basis to get through all of this. If we're looking at a more adversarial situation of a project which has probably been tendered to the lowest price and therefore margins are very, very low, and that's gone down through the supply chain, we're going to be in for a bumpy ride, I think, because it's going to be very difficult to persuade anybody ever to have a project bank account, but to go along with the kind of collaborative sharing of the pain, which will be required if we're going to get through this in a way that is not going to drive insolvencies.
Thank you so much, both. Really conscious of time today, so I'm trying to just sort of skip through. So, Anastasia, before we jumped on this call, you mentioned the role of MMC in the current context. So, it might be worth just sort of spending a couple of minutes just talking on that, and then we can nip forward into David's view on the sort of developers world and the knock-on implications.
I think Anastasia is having a few problems at the minute. I'll unmute you again, Anastasia, and see if we can get a better line. No, perhaps we can come back to you. And
Dave, do you want me to say a couple of words on that?
I was going to say, David, if you pick up on MMC and then pick up on all the implications for your development agreements that they're.
Of course, yeah, they're happy to. I mean, we've been involved in quite a lot of conversations even before, you know, with all the various crises that seem to have hit the construction industry in the last few months, supply chain issues, and obviously Mark Farmer's report that talked about, you know, the squeeze on labour, supply, materials, all those kind of things that people will be very familiar with. So the work had started already in terms of people starting to look at MMC. For those of you that don't know, MMC is modern methods of construction, which is quite an umbrella term. Some of you might know it's modular. So a lot of contractors have been quite up to speed and promoting it, but I guess the industry as a whole has been quite slow to react to the potential of MMC and how it might drive efficiencies in construction. Obviously, you know, great changes do promote innovation. So I suspect that the idea of having more construction done off-site, where potentially sites, you know, factories where parts of the works can be constructed off-site before being delivered to site. I mean, it fits relatively well into the circumstances of lockdown and where we see ourselves at the moment. So if anything, I think it's just accelerated those kinds of conversations. It will spark increased debate about whether it's a method of procurement that will help construction sites. So I think from our point of view, we do definitely see it being more and more widely adopted, if not considered, by developers.
Good. Okay, and that's excellent. Sorry, Rebecca.
No, not at all, not at all. So just then moving on, David, we're sort of looking at the knock-on impact to developers and development agreements, and I think we're all immensely aware, you know, the title of this is Collaboration in a Time of Crisis. You know, I think it's already been teased out by Duncan and Ian that just going very adversarial with your legal contracts and to Duncan's analogy of using it as a hammer is probably not particularly helpful right now. So it'd be great just to kind of touch on some of the issues and how are we going to deal with them going forward, because I think we all feel now that this is not a situation that's going to disappear in the next couple of weeks. We're going to be living with this for quite a long time, and you know, I think we're all going to be thinking about pandemics in our drafting of contracts going forward.
Well, absolutely, and as Ian and Duncan have quite rightly said, I mean, no one quite knows when the current situation will lift, and then going forward, if we may lapse into these circumstances again, albeit, you know, COVID or the next iteration in a couple of years' time. So I don't think we will ever escape the sort of drafting that we've seen in the past, as they've said about, you know, woolly definitions of force majeure. We've seen this from every construction contract is, as Ian said, it's such a combination of different interests. Quite a lot of what we saw early on was developers talking to their contractors and agreeing quite early on, or having conversations anyway early on about what immediately happens on site. Of course, that conversation can't happen in isolation. You're looking at third-party agreements, which covers things like development agreements, but also agreements for lease. Andrew will come on to talk about funding agreements. You may have other third-party agreements that have development obligations in there, so asset protection agreements and various other things. So, as a lot of the kinds of issues that have been flagged already in the construction contract are equally applicable up the chain in the development agreement. If you are lucky and your lawyers were talking to each other, your real estate lawyers and your construction lawyers at the time you were drafting things, hopefully they'll have collaborated on drafting. And what, in an ideal world, you'll have an agreement, a development agreement is absolutely back to back with your building contract. This being the real world, that doesn't happen that often, but the same kind of issues are there. You will have, invariably, you'll have some kind of completion date mechanic within your development agreement. Often, strangely, the sanctions which relate to suspension in development agreements often aren't as well developed as they are in building contracts. Often termination is talked about quite a lot up front in development agreements, but we haven't seen that kind of sophisticated drafting when it comes to, pausing on site or suspension. You've normally got fairly sort of basic provisions around hitting target dates. A distinction should be made really between target dates, which usually tracks the practical completion date under the building contract, and often that is a date which is movable depending on extension of time provisions, and we'll come on to talk about that in a second. What you often also have in development agreements are long stop dates. Again, terminology will change depending on your agreement, but usually a long stop date is a hard and fast date where the parties have actually sat down and thought, well, if this project doesn't happen and it's not completed within, say, a couple of years after we thought it might be, then both parties might have the opportunity to walk away from that. So obviously that raises its own issues. On most projects, you sit down at the beginning of the project and you really give some thought as to when this project might become commercially unviable, and you balance the risks that are involved in that, most of which are controllable by one or other of the party at some point along the way. Of course, the problem with the current pandemic is no one could have sat down even a year ago, even 3 months ago really, and said, well, what are the potential impacts of a disease which started in the Far East and then came across to the UK and shut down our entire economy. So you're looking at a long stop date, often because of the nature of that being a commercial long stop date. Those are often not movable. Whereas a target date, you will often have drafting which hopefully tracks extension of time provisions in the building contract, usually carving out anything that could be influenced by the developer. And you may indeed have carve-outs which track the JCT wording. So you might have either a list of specific events, extension of time events, or you may have a catch-all that says, and any event which is an extension of time event, a relevant event, for example, if you're using JCT under the building contract. Now, of course, the problem with long stop dates is that we are coming up to a position where there's no real certainty, even though construction sites are starting to open up. If you have a long stop date which is actually quite short, you may already be coming up or creeping up on knocking out the long stop date. The problem with that being, of course, that whilst target dates tend to have liquidated damages attached or some kind of sanction along those lines, when you get to the long stop date, often it is a termination event up the chain in the development agreements, and obviously losses and things can flow from that. So it's a tricky conversation to have. You're probably having that with your building contractor, and he in turn is having that with the supply chain. But if you aren't having the same conversations up the chain with your developer, the owner of the site, the funders, operators, these kind of things, then you may well find yourself in trouble later down the line. As the guys have said already, to the extent you do come up with a commercial agreement, you will want to, of course, first check your contracts thoroughly, because how can you go into a commercial conversation with various parties unless you know what your fallback positions are, what you can agree, what you can't agree. But equally, we're in such strange times that even, I think there's a distinction between the courts when and inevitably when these provisions come in front of judges and the courts, they are going to look at the circumstances around it. They may not apply the contractual terms as strictly as they might do in normal circumstances, just given the size of the issue that we're facing. So no one can quite predict how these things are gonna pan out. The safest course, and what we've been advising most of our clients to do, is to have those commercial conversations early on, where possible. Try and agree something that is documented legally in a settlement type agreement where you've actually decided the consequences. I think the courts are going to look very favourably on parties who start to do that. I know we've been mentioning that collaboration was the watchword when the pandemic first kicked off, and perhaps some of that goodwill has ebbed away over the weeks. But I think in general, I think people are still willing to get around a table and actually try and agree something a bit more formal and the consequences of that. And by far that appears to be the better way to go.
That's really helpful. Thank you, David. Anastasia, we'll try again. Have you got anything to add to what David said?
Can you hear me now?
Yeah.
Oh, good. Okay. I've moved rooms, hoping that would help. I'm sorry about that. No, well, that was what I started saying earlier about MMC. Just to add, I think I missed the beginning of what David was saying, but just from my experience, it's only going to get more and more prevalent. I think we're just going to see more and more of it. And then from a legal perspective, obviously everything that comes with that, supply chain, step in, and all those kinds of conversations that you're going to need to have. I mentioned this morning as well about the NHBC just approving some additional elements of MMC. So I think the market is sort of following that as well, and accepting it as more of a standard form of building, which is great. And the other thing too, I was thinking on the construction side as well, is sort of sustainable or green initiatives and sustainability. I think that's going to be top of the agenda as well, not only from a policy perspective, but also just from an industry perspective. I think that's the way we're all going to have to go.
Great, thank you. Andrew, anything to add on David's points before handing over to you to talk about funding?
I think really it sort of leads on really in terms of the sort of things that David was talking about are issues we're getting coming up in the same way in forward funding agreements. Can I just check you can all hear me, by the way, there as I switch back on? I mean, just a couple of sort of specific examples, the sort of things that David was mentioning with long stop dates and that sort of thing. Other things on date provisions that we're starting to have to look at quite closely in forward funding agreements is things like your handover regime. And from an investor perspective, for example, we often have very specific requirements built into the handover, which may not be exactly back to back with your building contract and practical completion of your building contract, because you've actually thought from a legal perspective, what are the other things that an investor wants to see at the point where it's about to part with an additional big chunk of cash, maybe in terms of profit payment, or if it's a forward purchase on sort of completion. And people have often thought quite carefully about what they want handed over at that point. And you could suddenly have a situation where bits of paper that are part of the list, like even simple things like instruction manuals for the washing machine,
aren't available because the washing machine manufacturer didn't have the right people in the office, or documents you wanted out of the planners. So I think people are going to be looking very closely if they either want to hand over a building, or if they potentially don't want to hand over a building because you're about to take on a new building at a time when it's going to be pretty difficult to get viewers around, and your letting up period might be going to be extended, and so you're thinking about potential liability for void rates if, as an investor, you take the building on. So I think we'll have a combination of looking very closely at the existing drafting, but then as we go forward, people are again going to be very careful about these sort of provisions, not just in terms of extensions of time, but thinking very carefully about things which might not be directly under your control. And then Dave mentioned the LADs, and I think in forward funding agreements, it's often the case that you don't have LADs in a forward funding if you're looking for an investor, looking at it from an investor perspective. Now, the developer might have LADs against his building contractor, but if you've got a coupon arrangement, so you've got notional interest clocking up on the developer's part, now all these extensions of time might be great because you're thinking, well, we're not going to be liable for a breach of contract, because unlike student deals, you don't usually, in a forward funding context, have the same degree of obligation to deliver set dates. But you may not have taken into account when you were working out your margin and your balancing payments at the end, quite how long your coupon was going to be rolling up for. And so it's going to be eroding away the profit and causing people to look at that very carefully. And I think in future, when we're drafting forward funding agreements, I think with developers, we're going to be thinking, well, what if there is an unexpected delay? What happens about the coupon if it's a delay that's beyond your control, that's this sort of circumstance? Because what you don't usually have is a provision that the developer can stop accruing coupon in situations outside their control. And I think the other sort of things that we'll be looking at and people be having to take decisions on handover is, you may have given a lot of very specific thought to exactly how you wanted your building handed over, so you already start putting tenants in. And what happens if it's very specific elements that you wanted that aren't there, and you're going to look at alternatives? So again, links back to some of the things that David talked about. And I think people will be looking very closely at the step-in rights under existing contracts, because you've got, I mean, as yet we've not been seeing insolvencies happen, but we might start to see that. And so you're going to have step-in rights to look at different stages. What if the developer goes bust, stepping into his shoes as employer? Or alternatively, what if the contractor goes bust? What's the developer going to do? So I think there's a whole series of things that we'll be looking at on that side of it. And just in sort of related agreements that we're looking at in the whole sort of forward funding and operational business side of things, management agreements. I mean, the idea of property management agreements is something that people have had to get more and more focused on the detail of these as the industry's got more savvy about the issues in management in built to rent. And traditionally, they didn't have sort of blanket force majeure sort of provisions in from a property management perspective. But I think now you're going to see managers thinking we should have some force majeure COVID-19 protection. But then from an employer's perspective, I know the last couple of months have seen a lot of sort of, I think, plaudits for the build-to-rent industry because of the way that the build-to-rent, quality build-to-rent operators have been able to look after their residents, even if they've been closing down some of the commercial, some of the communal areas. And I think people will want to legislate quite clearly for what they're expecting of their manager. If their manager wants to rely on a force majeure COVID-19 provision, what are you going to expect the manager to be doing in return? But then the other side of the coin that we're looking at a lot at the moment is quite what's going on in debt. And the biggest, probably the biggest issue that we've been encountering at the moment, either with getting new schemes to proceed or looking at things that are already there, is how people are dealing with the drafting of and the enforcement of loan to value covenants in a situation where suddenly the valuers have got the market uncertainty clause that they're putting in. So no one could really rely in the same way on those valuations. And that's giving rise to a whole range of issues to think about on the legal side. But I think, again, one of the other, another topic that underpins all of this in terms of what your contractor's doing, what the implications are for the developer, you've always got to think very carefully as well about what is your funder's position, your lender position on things. So be very careful if, as a developer, you go into discussions with your contractor without thinking, hang on a minute, we best be a bit careful, what are our banking covenants here? So that's a quick overview from my perspective.
That's incredibly helpful. I think at the moment it's sort of a demonstration that everything's changing so quickly. And as you say, Andrew, the RICS's valuation wording at the moment, I think questions are going to be asked in the long term as to whether you actually can raise any type of funding off the basis of the valuations that are coming out at this moment in time. So,
Rebecca,
yeah,
sorry, can I add just one small thing to what Andrew said? We had quite an interesting situation this week where one of the major UK banks suggested they would be temporarily accepting collateral warranties electronically signed, which is quite a helpful, obviously in the current lockdown circumstances, getting CPs in terms of collateral warranties, especially where you're getting them sometimes from quite small subcontractors with not necessarily a lot of technology in place, or unable to open their offices, has been quite a bit of a blocker. So it's been quite useful that the banks are being as helpful as possible. What would be even more helpful, I think, going forward is if they were to take that approach potentially coming out of lockdown, and if they relaxed their requirements maybe in terms of accepting electronic signatures of things like warranties going forward, that might be quite a big efficiency game changer in construction and development.
Couldn't agree more. And I think actually, as Nicholle touched on right at the beginning of this, it'll be interesting to see how many of these measures are then kept for the long term, or how many are kind of temporary and we all sort of begin to sort of drift back. Anastasia, conscious that we've got sort of 5 minutes, so it'd be great to kind of have you sort of wrap up any further thoughts, any commentary on what you sort of future gazing, what you think is going to happen in the coming few months, and anything to be aware of.
Yeah, thanks, Rebecca. Just a couple of things to pick up, maybe particularly from that future gazing perspective, if I may. One is just around key workers. I mean, I think there's a lot, obviously, around that, which I think we'll just see more and more of in the coming months. I mean, there's clearly despite this is more of a sort of policy issue, I suppose, but it will feed down through planning and into our development agreements. Just in terms of, there is a disparity of key workers who work in the centre of town but have to travel in, and I think that's been made, it's highlighted so clearly over the last few weeks and everything that they've been doing. And there is a bit of an affordability gap, really, isn't there, between perhaps some elements of build to rent and key workers. So I think that it would be great as an industry if we could really embrace that, and accommodate have accommodation for key workers within the developments, and everything that means in terms of management, how that interacts with other sort of more affordable elements of your developments will need to be looked at in a bit more detail. And the other thing is I think Andrew mentioned amenity spaces. I think these have been, again, looked at through a completely different lens with everything that's happened over the last few months, and reconfiguring your amenity spaces, perhaps not having your cinema room or whatever, but having a more flexible space, co-working space. And again, what you know, how you look at that from a planning perspective, whether a funder will still be happy to go ahead, or whether, you know, whether they want to say in how things change in a particular development from that perspective, will be quite interesting to see, and how easy that is to do from a design perspective as well. So those are a couple of things I think to look out for. But the key workers piece, I think, you know, we've already seen as an industry, and the BPF have been doing a lot in this space as well, and, you know, sort of accommodation and licenses and things for key workers. So I think there'll only be more and more of that from a policy perspective we've got to look at, which will feed down into our legal agreements.
Thank you. It's really helpful. Dave, anything else that you'd like to add? Oh, you're on mute.
Okay, so no, I think it's been a fascinating debate, fascinating discussion. I mean, we started off talking about collaboration, and we've been jolly collaborative. I hope the sector continues that, but I think that some of the practical issues that have been spoken about by everyone on the panel will present some challenges to us as an industry and legal friends as lawyers. I thought perhaps I ought to go back to the question that Peter Sloan asked back about 50 minutes ago. And Nicholle, I don't know whether you've seen this, but the question he asked was, do the panel support a more dedicated planning class to the BTR sector? And has anything about COVID changed our views on that?
Yeah, thanks for that. Actually, interestingly, because it follows on from the discussion just now in relation to flexibility of uses. Generally, across the industry, there is a call for government to amend the use classes order, to get it up to date. With current position, it's woefully archaic and out of date in any event. But B, to provide the flexibility that we need in the uses and switching as between uses as a result of, not just as a result of COVID actually, but it obviously brings it to light. For example, if you're looking at town centres and the ground floor use or mixed use buildings, and obviously build to rent uses as well, you want that flexibility to be able to switch between the uses. So I guess in response to the question, I'd ask why would you want a separate use class for build to rent? There are clearly advantages and disadvantages for having a separate use class. But actually the momentum at the moment is for flexibility in the uses. And so personally, from my point of view, I'd probably stick with the C3 use because it gives you that ability to flip as between build to rent and build for sale if you want to, and you can cover off your restricted covenant clawbacks provisions in your section 106 agreement, and you can cover off how you approach viability and obviously clearly the different economics of build to rent as you work through the planning process, through the mechanisms that are there. So I think I support the flexibility of being able to switch between uses and keeping it as open as possible. But I do think the government does need to have a look at the use classes order in particularly. It's something, as I said, that we needed to do anyway, but it has certainly brought it to the forefront as a result of the COVID-19 emergency.
Okay, Nicholle, thank you. That's very helpful. And I think you made the point well that flexibility is often best served by an absence of detailed wording as much as clarity is not. Does anyone else want to come in on that point? No. Okay, no, very happy to leave Nicholle to be our expert on planning and usage. And I think we're now at 3 o'clock, and unless there's any final points that any of our panel want to make, no, then I will say thank you to each of them for, I mean, just like the last legal panel we ran, I come away thinking, oh my God, there's so much to know. and it's such a complicated world we're starting to move into. And to say thank you again to all of them, and thank you to all of you for coming and viewing this. And Rebecca, thank you particularly for your co-chairing. And apologies for anyone who's struggled a bit with the internet. I'm told the weather is still one of the things we can't yet control, and it is affecting the quality of the signal and some kind. But if you've missed anything, there will be a recording of this on the UKAA website, hopefully in about 48 hours, which should enable you to hear all the words in glorious detail again. Apart from that, it's just time to say thank you and goodbye, and I hope to see some of you again tomorrow. Webinar tomorrow afternoon is by Smart Rent. We've got a really interesting view from the US, an entrepreneur who runs Smart Rent out there, talking about technology in the BTR sector and how he sees things changing. And interestingly, they're funded by Amazon, and some really interesting thoughts of what Amazon want to try and do in the sector. So join us tomorrow afternoon. But again, finally just saying thank you to the panel. Thank you for joining us. Goodbye.
Thank you.
Thank you.
Bye.